yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save you, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to this session of the Tennessee Supreme Court here in Clement Auditorium at Aston P. State University. Our Scales Project brings together judges, attorneys, and students to develop a better understanding of the judicial branch of government and the role of the courts in our society. Unlike the cases you see on with real lawyers representing real clients and real judges deciding the issues. We appreciate your participation, and we hope you enjoy the case that you're going to hear today. I want to thank Aston P. State University and President Mike Licari, as well as the staff here at the university for hosting and helping coordinate this event. Specialists Adrian Fry and Katie Olita of the 19th Judicial District and Sharon Massey Grimes as well as the additional stakeholders who have worked hard to make this event possible. And to the volunteer judges and lawyers, for your willingness to work closely with the students in preparation for today. And to the participating schools, we thank the administration, the teachers, and the students for your participation. We also want to recognize the Clarksville Police Department and the APSU Police Department who are assisting us with security today, who are arguing their cases, and for the extra effort and time we know that has been required of you for your participation. I'm going to ask our newest justice on the Tennessee Supreme Court, Mary Wagner, to say a few words to you about our cases today.
Good morning. I am so thankful to be here with you a few minutes to share with you about our judicial branch. I'm sure as many of you know and have studied, the federal government operates with 3 branches of government. Hopefully you also know that our state government operates very similarly. We have in Tennessee an executive branch, Governor Bill Lee. We have our legislative branch, which is the Tennessee General Assembly. And then we have our judicial branch, which is us. The executive and legislative branches are more political. They adopt policy decisions, pass laws, oversee the state budget, and really decide the direction of our state. We judges, however, are different. We do not make policy decisions or voice personal opinions. That's why you often won't see us in the media or on social media commenting on laws or certain cases or voicing our. Instead, we are tasked with upholding the constitutions, both of the United States and the state of Tennessee, and the laws of the state of Tennessee as passed by our General Assembly. We do that through an adversarial system, and it may sound like we like to fight and duke it out, but that's not what that means. It simply means that we resolve actual disputes between real parties who may have disagreements on the facts or the law or how a problem should be solved. You will get to see those in a few moments in real-life cases. Through our court system, the parties present their view of the facts and the law, and we as a neutral party decide those disputes. Sometimes the ones making the decisions are judges deciding the facts, and sometimes at the trial level that's a jury, where the judge serves more as a referee. It begins at the trial court level. You will likely hear today about what occurred at the trial court level, and then if the parties disagree still, they may appeal to the Court of Appeals or Court of Criminal Appeals, and then if they're still unhappy, they can seek to have our court to review it. Ultimately, our goal is to find the truth that we have chosen to live under, and the judicial branch is one important part of that. Of course, we can't do that without you all, so we need your support and confidence in the court system. We know the court system and how it works and how important it is. So we thank you for being here with us today and hope you will stay engaged in the future. Chief Justice Kirby.
Thank you, Justice Wagner. We hope that all of you will stay engaged with the judicial branch after court today. You can follow us on Twitter at TN Courts on our website, tncourts.gov, and on Facebook. On today's cases will be posted to our website and to our Twitter feed. Now I want to introduce to you the justices of the Tennessee Supreme Court. I'll introduce them according to their seniority. First is Justice Jeff Bivens. He's political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville, served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel, and has served as a trial court judge and a judge on the Court of Criminal Appeals, our intermediate appellate court. He's been a justice on this court since 2014, and he lives in Franklin. Justice Sarah Campbell, to my immediate left, earned her bachelor's degree from the University of Tennessee at Knoxville and a master's degree from Duke University, doctorate from the Duke year. She served as law clerk to Justice Samuel Alito on the United States Supreme Court. Prior to her appointment to the Tennessee Supreme Court, she was Associate Solicitor General and Special Assistant to the Attorney General in the Tennessee Attorney General's Office. Justice Dwight Tarwater, to my far right, earned his bachelor's degree and his law degree from Tennessee at Knoxville. He served as general counsel to former Governor Bill Haslam for 6 years. As a litigator, he has managed hundreds of cases at the trial level and the appellate level in the federal and state courts, and was a nationally recognized, accomplished trial lawyer. Justice Tarwater lives in Knoxville. Justice Mary Wagner is the newest member of our court. She's a graduate of the University of Colorado and the University of Memphis School of Law. She practiced law for a number of years in Memphis before being appointed as a circuit judge. She was elected twice to that position to our Tennessee Supreme Court in 2024. Justice Wagner lives in Shelby County. I'm Chief Justice Holly Kirby. I graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. I clerked for a federal appellate judge and then practiced law in Memphis. I served on our Court of Appeals for civil cases for 19 years before being appointed to this court in 2014. I live in Memphis. Part of our state laws of Tennessee. Now we're ready to get to work. Jim Hibner, our appellate.
Good morning.
Good morning, counsel.
May it please the court, Jeffrey Zager, along with Olivia Arbonneau on behalf of the appellant.
Committed to upholding the Constitution, protecting individual rights.
And Randy Locke. I'd like to reserve 5 minutes of time for rebuttal and commandeer that space, if I may. This interlocutory appeal centers on the discoverability of surveillance videos. Specifically, what happens when one party obtains surveillance video, only intends to use all of the surveillance videos it has obtained. So, relying on a Michigan federal trial court decision, limited discovery to only those videos that the defendants intend to use at trial, concluding that the plaintiffs do not have a substantial need for videos that will not be played at trial. That conclusion finds no support in Tennessee case law, and it runs counter to the basic notions of fairness and transparency that are embodied within our rules of civil procedure. More problematically, it has the practical effect of allowing a party to unilaterally render surveillance videos immune from discovery simply by declaring that it has no intent to use those videos at trial. I think the facts and the procedural history of this case are fairly undisputed, and so unless the court has specific questions about those, I'd like to dive into the issues at hand.
Let me ask you, does the substantial need test, according to your position in this case, should we retain the substantial need test, or Is that, did you answer? I'm sorry.
I see no reason to disagree as to the legal framework, which includes the substantial need test. So our position is not that substantial need should be read out of Rule 26 or out of the analytic framework for discoverability of work product or surveillance videos. The dispute here, do we go about that assessment of substantial need, specifically in the context where a party has obtained surveillance videos and expresses an intent to use some but not all.
Did you ask for an in-camera inspection in this case?
We raise of, and I guess it is somewhat important here to retrace the procedural history. The original discovery request sought surveillance videos. An objection was raised as the basis for not producing those. In the original motion to compel, which was filed, we pointed out that there had been no privilege log provided. In connection with the response to the motion to compel, a privilege log was provided. I think it's Exhibit B to the defendant's response. That privilege log lists 6 videos, 6 entries, and an investigator's report. Through the initial motion to compel hearing, subsequent hearing on the motion to amend the trial court's ruling, it became evident that the 6 entries in the privilege log represent only the videos that the defendants intend to use, not the videos that are still being withheld under a claim of work product and the defendants have offered they do not intend to use. Once that became clear, yes, we did raise at the trial. This is in violation of Rule 26. There has been no identification of what is being withheld, and we can't even really fairly assess substantial need until we actually know what is being withheld. For whatever reason, that argument got very little traction at the trial court and was never really addressed. It's not addressed in any of the court's rulings. We did raise the issue that we have not even been provided. It's not going to be videos. They are. We don't know what they show. The trial court of any actual information about the videos other than the fact that they will not be played at trial.
So were the 6 that they intend to use, were they produced?
They were produced after the trial court's ruling, I believe after the ruling on the motion to amend, at least after the original ruling on the motion to compel.
Okay, and then you asked for a privilege log for the other videos that weren't produced?
We asked for a privilege log from the outset, yes.
Okay.
But did they ever provide, so they have never provided a privilege log for the other videos in their possession that they do not intend to use at trial?
That's correct.
How does that, if at all, affect who bears the burden of persuasion on these privilege issues? I mean, is it your argument that they haven't actually properly invoked the work products protection for those videos because they failed to list them on a privilege log?
I would certainly say that that's a fair argument to make. I think it also speaks to the fact that the trial court's ruling is a ruling of law, because as a practical effect, there was no ability for the trial court to actually assess these videos because the only information the trial court knew about the videos was the fact that they were not going to be played. So it's a bit of a misnomer to suggest that the trial court actually assessed substantial need. There was no in-camera review. The trial court knows nothing about the videos other than the fact that there is no intent to play them at trial. And I would say that, yes, that does, I think, fail to comply with Rule 26 in terms of raising work product. I think Rule 26 is pretty clear that if you're going to make a work product objection, you need to provide the other party and the court with some information of that claimed privilege. Here, the only information that was provided to support that claim was use them at trial.
Let me press a little more on the question that Justice Tarr about what the correct framework is here. So in response to that question, I believe you argued that you agree that the substantial need analysis is the right way to approach this. But it seems to me there are sort of two ways to look at the legal issue here. The first is, whether there was a sufficient showing of a substantial need for these materials kind of within the Rule 26 framework. But another way of looking at this is that the defendants, by intending to use certain of these videos at trial, have waived any applicable work product protection as to those videos. And then the question becomes, what is the scope of that waiver? As part of that waiver, are they also now required to disclose the other videos that are related to those, so that, under the rule of completeness or just principles of kind of equitable fairness, you have the full picture. I know you made an argument in, I think, your brief to that effect, that this is kind of about the rule of completeness or waiver. How does that fit into this? Did you make that argument below? What is the right frame? Because those are really two different ways of looking at it. I think if it's a waiver, if that's really the framework that we're within here, then whether you show that there's a substantial need for these materials is to that inquiry. So what is the right way for us to look at this?
I agree completely, and I think that Your Honor is correct that those are two equally valid ways of approaching this question. And we did talk about waiver in the context of sort of the sword and shield argument about when a party voluntarily elects to put forth some information that it was previously claiming a privilege to, it cannot then at the same time claim privilege for some other subset of the same information. I think this court has made that abundantly clear in the Boyd opinion, which I think the defendant on Boyd is very clear that litigants may not use the work product doctrine offensively as a sword to make a point and then selectively disclose information that they wish to and relinquish that work product doctrine effect, while at the same time invoking the work product doctrine to prevent the other side from making a count. I think that there is waiver in that context.
But did you raise that argument in the trial court?
Not initially, and in some respects that was a function of the procedural posture, because the original motion to compel was in the context of an objection to not producing any videos, they're all work product. It wasn't really until we got to the motion to alter or amend, after the trial court had already ruled on the motion to compel, that this new theory from the defendants emerged of, well, we should only have to produce some, not all.
So it wasn't until that motion to alter or amend that the defendants court that they did plan to use those videos at trial? Is that right? Is that the point in the proceedings at which it became evident that some of those videos would actually be played at trial?
I think that is correct, that it wasn't until the motion to alter or amend on the motion to compel initially, I can't recall, it's been several years, but certainly the motion to alter or amend was the first time that the defendants specifically asked the trial court to carve out an exception to say, well, we should only have to produce the videos we intend to use, which to me was their clearest statement that there are other videos being withheld that are not contained in this privilege.
And at that point, did you raise an argument about waiver of the work product protection or the rule, anything with any argument kind of within that framework?
I believe the argument that would be contained, which would have been in our response to that motion to alter or amend, did include the sort of sword and shield argument about it, particularly, it was probably framed in the context of substantial need, but to me they overlap there. That when you are affirmatively seeking to use surveillance videos, there is of course a substantial need for all of them, and that goes hand in hand with the idea of you have voluntarily elected to waive the work product doctrine with respect to some subset. In fairness, in full transparency, to provide context to the jury, they all ought to then be disclosed. So I think it goes hand in hand with the substantial need context. I can't tell the court specifically from my recollection whether we made a specific waiver argument, but to the base, that sort of sword and shield type of argument at the trial court.
To follow up about the rule of completeness, why would an evidentiary rule, which is right there in Rule 106, apply to a discovery dispute?
It's not binding, but I think it's instructive in the policy rationale that it embodies, which is that in fairness, the full context of evidence ought to be provided to the jury, and that we don't let sort of hyper-technicality allow what is a context ought to be displayed. Okay,
on that. And let's move to the other side of the V, to a day in the life video. Is it your position then, so if you represent a plaintiff and you produce a day in the life, hundreds of hours of footage, and you elect to play 15 or 20 minutes of that footage for the jury, that all of the remaining footage.
I think a day in the life video is no different than surveillance video. It's just voluntary surveillance video. And I think if there's a substantial need for one, there is a substantial need for the other.
But the substantial need test applies, right?
I think that certainly is the test that every court that we've looked at in these cases is applying. I will note, I think it was an Illinois case that was, I think, cited by the Tennessee defense parties, may have been Helms. And
well, C for you, H for me, you know.
It's all relative. And in that case, the court, I think, held that it would reserve ruling in the context of a day in the life video. It would reserve ruling on the discoverability of the day in the life video, including the unused footage, until the plaintiff made an election of whether or not to actually use it at trial. And I think arguably you could make an argument in the context of surveillance videos. That issue isn't really before the court because here we already have an affirmative statement from the defendants that they intend to use surveillance videos at trial, but I think that would still be a fair card. What happens if a defendant says we have surveillance videos but we don't intend to use any? Is there a threshold requirement of some intent to play some video to then trigger a substantial need to all videos? Either way, it's still the same analytical framework of substantial need.
So here in this case, what you're saying is if the defendant said, we've decided we're no longer going to use any of this video, then you would no longer have substantial need to see it.
I wouldn't feel so comfortable as to establish a bright line rule that if one party declares it has no intent to use the videos, there can never be substantial need. I think the framework would still be the plaintiff's burden to establish substantial need, and I would think it would be a more difficult task
But
in that
right
context.
Right now, your need is really on a completeness level. We want to see if the video that they are seeking to use is somehow selectively edited, misleading, and so forth.
Correct.
So that argument just wouldn't hold anymore.
That's right. That's not to say that there might not be a different valid substantial need argument in the context of a situation where no videos are going to be played, but I think it would certainly be a more difficult
But in this case, you would agree that if they were to say we're no longer going to do that in this particular case, you in essence would not have a substantial need for those videos.
We certainly wouldn't have the same substantial need argument that we have, and I can't envision a different substantial need argument in the context of this case. You know, the examples I'm thinking of is perhaps if the plaintiff passes away, or if there's some really unique situation where this video there is a substantial need for it. Those circumstances don't appear to present here.
Okay, thank you.
And so as I see it, there are, I think, three outcomes that this court, three paths that this court could take with this case, and any one of which would be certainly permissible. I'll offer them in my order of preference. The first would be that this court, our position would be, can and should establish a bright line rule that anytime a party announces an intent to use some but not all of the surveillance videos in its possession or custody or control, then there is, as a matter of for discovery of all the videos. I think if the court is unwilling or uncomfortable with such a bright line rule, then it can, at least in the context of this case, of the facts that are in the record in this case, conclude that there is a substantial need for discovery of all of the surveillance videos based on what we know about this case.
And how do we do that? With no privilege log, with no in-camera inspection?
Because we do have a privilege log. I
know, but the videos on the privilege log are the ones they intend to use at trial.
Correct.
Okay, so there's no listing of any video or any piece of evidence that they are claiming the work product doctrine for. So how are we then to determine substantial need?
Because in this context, the other piece of information that we do know from the investigator's report, which is also contained on the privilege log, is that all of the surveillance, the entire universe of surveillance, both what they intend to use and what they do not intend to use, was taken on the same day. And so that, to me, is sufficient to establish substantial need in terms of providing context for particular universe. I think it might be a different question if there was such a gap in the temporal context of this group of videos, but this one was years later. We're not going to play it. It has nothing to do with this this subset. That's not this case. We know that all of the videos here were taken on the same day. And so I think
And that's supposed to establish substantial need because they were all taken on the same day?
I think so. In the context of this case with Rule 26 as a backdrop,
And rule, as you've articulated, is option number one, that we send the case back to the trial court with instructions to have the defendants produce a full privilege log, and then the trial court could do an in-camera review of those items.
yes, and that is my option number 3, which
Okay.
is that at minimum, this court should remand the case to the trial court for an in-camera review of the withheld videos with the instruction that the non-evidentiary status of those videos, simply declaring we do not intend to use them, that in and of itself is not sufficient to negate substantial. Really, the trial court's holding here is that once you have declared you don't intend to use them, substantial need cannot be. There will never be a substantial need. So I think it needs to be remanded for an in-camera review, but also with some instruction that the evidentiary status or the intended evidentiary status of the video is not part of the analysis, or certainly is not sufficient to negate substantial need.
And is option 4 to affirm?
It would be. It's not on my list, but that would also be an option.
Did I miss option 2?
Option 2 would be that in the context of this case, based on
Okay,
this
so no bright
record-
line rule, just based on the facts of this case.
Correct.
There is a substantial need here.
Yes, Your Honor.
What about, so if the right way to approach this is through the waiver framework instead of the substantial need framework, and I understand your argument that there may be some overlap between those analyses, or could be some overlap. And if that's the right way to look at this, what would be appropriate, or is that something we could decide as an initial matter?
I think if the court were to take the waiver path, then there would be no need unless there was some sort of
But would
unclear
in-camera
fact.
review be necessary to really decide whether it's appropriate
I don't-
to require disclosure of those materials under the rule of completeness or a subject matter waiver?
I don't believe it would, because I believe what the court would be ruling is that by selectively electing to disclose some of these videos, the defendant has waived the rights. Therefore, there is no need to have an in-camera review of what the videos
Well, but
show.
doesn't a court still have to decide, what is the scope of the subject matter waiver? What else is sufficiently related to the items that the party does intend to disclose, to constitute a subject matter waiver? I mean, here we don't even have, I know you're telling us that they were, and that's in the record, that we know all of these videos, that the videos that are not on the privilege log were on the same day as the videos. Is that in the record?
I believe it is. I know for sure that it is in the trial court, well, I shouldn't say record. In addition to producing the 6 videos that were contained in the privilege log, the defendants also produced their investigator's report. I know for sure that provides all the surveillance took place on one day. I don't believe that investigator's report is in the appellate court record because it would have been disclosed after we were off on our appellate path. Certainly happy to supplement the record to provide that document.
Is the mere fact, even if that's in the record and we know they're produced on the same day, what if they were different locations? What if it was different, there were some videos in the morning, there were some videos in the evening, and they were entirely different locations? Would an intent to use, one subcategory of those videos necessarily mean that there was a subject matter waiver over all of the videos for the entire day? Or wouldn't the court actually need to take a look at that with a better developed record?
I think in this context, the answer is still no, that the court does not need to do an in-camera review. And I think the cases that we've cited on internal investigations are instructive on that point, where there are cases holding that simply offering part of an internal investigation or placing part of an internal investigation into the record waives the entire investigation out. Well, the part that you elected to disclose really only deals with this one concept, and that's the limit of the waiver. The courts are pretty universal in saying if you want to use part of it, it's all fair game, at least in terms of discovery. And I think the court can also find some comfort in discoverability. And so there's always going to be that fallback of the rules of evidence, a very sort of default Rule 401, 403 analysis as a safeguard to making an argument, well, in this context, we shouldn't allow the plaintiffs to show these videos, even though it should be the appropriate avenue for addressing those issues rather than trying to carve out or narrow the scope of discoverability. There is, and I recognize that I only have about a minute and a half left, so I want to raise one issue that I think is really important, which is in the context of the substantial need analysis, if that's the path that the court elects to go on. The trial court and the Court of Appeal, great concern with the idea of not allowing videos to be produced if the purpose is to corroborate the plaintiff's own testimony. And I want to be very clear that that is not our basis for asserting substantial need. Our position is not that these videos ought to be produced so that the plaintiff can prove her case in chief. And I think when courts talk about corroborating plaintiff's testimony, I read the language of those cases as dealing with plaintiff's burden of proof to check the prima facie elements of her case: duty, breach, causation, injury. The plaintiff has the burden of establishing injury, and so if the argument was, we need these videos in order to prove our own, that's what courts have held is not a substantial need, and that is not the argument we are making here. We're not advancing an argument that we need them to prove our own case in chief. We are making the argument that especially, and I recognize my time is up, but if I finish that thought, especially in the modern era of what is capable with respect to video, I think this court has to recognize that there is a substantial need for probing, at least from a discovery standpoint, whether or not a video that is being shown is misleading, is incomplete, is in some way not providing the full context to the jury. And at least from a discoverability standpoint, I think there is a substantial need in this context, unless the court has any additional questions.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Brigham Dixon on behalf of the Nashville Bar. May it please the court, presenting an argument today on behalf of the defendants and appellees. It's also my first time before Your Honors, and of course with the scales here. There are some foundational issues with the arguments that have been presented by Mr. Zager, and I want to address those, particularly with the record in this case. I think to understand these issues with privilege log, what's been produced, and claims that videos have been withheld that are unsubstantiated, back to the original motion to compel and the order that was originally entered on the motion to amend or revise that order. We, at all times, have maintained the privilege of the work product doctrine over all surveillance videos. That led to a motion to compel.
When and how did you invoke that privilege?
In discovery responses. They requested all videos, anything we might have of Mrs. Locke. In response to that, we said we object of trial preparation materials, work product doctrine, impeachment evidence, etc.
But would you agree that producing a privilege log is necessary to properly invoke either a privilege or a work product protection?
Yes, and a privilege log was produced. We have a privilege log that was produced, and we've never waived the privilege.
But the privilege log include all of the videotapes, or
yes,
just the 6 that's being introduced?
And that's why I think there's some confusion here. And what you're referring to is representations by Mr. Zager that is based entirely on what I'm getting at with this, how this order has changed. The order as it was originally written by the trial court, by our interpretation, would have been to discover surveillance work product regardless of whether it was intended to be used at trial.
Can we go, sorry, can I step
Yes.
back just a second? Okay, so you've fast forwarded to the order. Let's go
Yes.
back to, you produced a privilege log before the order, the initial order of the trial court requiring.
Produced a privilege log once I have to double check the timeline, and I'm sorry for not having that available offhand, but we produced a privilege log at least when we were required to identify all of the videos under which we would claim work product.
Okay, and are the videos that you do not intend to produce at trial on the privilege log?
And this is the key issue. There are no videos that are not included on that privilege log. The whole basis for this argument is because we sought to revise its order. because we felt that it meant any surveillance we obtained, if we intend to use it at trial, that we must disclose it. The trial court agreed. Now, based on that, plaintiffs and their counsel have surmised that because they have a non-sequential numbering of videos that were provided, that there's some other listing of videos. That's never been represented, that's never been disclosed in the record, and frankly, they've had the opportunity to conduct discovery. They've known who the private investigator, nothing to understand what that meant.
I'm not following.
Okay.
So if I understand you correctly, what you're saying now is that the privilege log that you used actually identifies all videos,
All the videos.
whether you're going to use them or not.
There are no videos from that private investigator listed on that privilege log that we're withholding. The only basis that
Well,
has
right,
been
but
used.
that's sort of,
No,
but
that's not
Yeah,
the
that's
question.
circular.
Yeah.
What Justice Campbell is asking
Okay.
about, what are you asserting work product?
But we've produced it, and we've informed Mr. Zager
Where
of that.
have you identified anything that you are asserting work product over that you are not going to use?
There are no materials over which we've asserted work product in the surveillance realm. Obviously, there's other work product, but as to surveillance, there are no other videos that this firm, my firm, has obtained.
You're saying all this very, very carefully.
Well,
I'm trying to figure out what you are not saying here. I'm
why are we
hearing
even
holes in what you are describing.
Okay.
And I feel like I'm not getting just a full-on, straight answer. You are asserting, we wouldn't be here asserting work product over video think the plaintiffs ought not see. What I'm asking is, where is that identified? In order to assert work product, you have to identify what you're asserting it over. Where is that identified?
So I have to, I don't mean to be cagey, I don't mean to be misdirecting. The issue here is we were ordered to produce what we were intending to use at trial. We did that, and we have no other videos. But the order that was by Mr. Zager, because he requested all of the videos, and now there's an order in place that only limits it to the videos that are intended to be used at trial. Now, the reason I think this is an issue, this case is ongoing. There's a future possibility for additional, and we wanted to, if they have a need for some video, such as what we're going to use at trial, which is not disputed, then they would arguably be able to obtain any future surveillance, anything that is in that category.
Are you saying that this appeal is over as yet non-existent video?
There is, yes, because the plaintiff has not developed that record whatsoever. If you look in the record, there is nothing there to show that there are videos that have been withheld. It is pure speculation, it's pure conjecture and innuendo.
So
And it's
you're
their
saying
burden.
the trial court first ruled that the videos must be produced, and then you filed a motion to alter or amend to only produce videos that you intended to use, and so you filed that motion for some hypothetical future videos that don't yet exist?
No. The reality here is that we're in Davidson County with an order that can be used in numerous other cases, the largest county in Tennessee. And there's an order in place that said, as we interpreted it before it was revised, that a plaintiff is entitled to surveillance whether we intend to use it or not. We said that's not an appropriate ruling. We want it to be revised. The court agreed based on its own precedent that it relied on and the precedent that Mr. Zager first proffered.
All right, let me,
That
is there surveillance video that you have taken that in existence right now, not hypothetical in the future, in existence right now that you have taken on behalf of your client that you are not, either have not already produced to the plaintiff or are not willing to produce?
No.
Then I'm completely puzzled, Mr. Dixon.
Why are we here?
We're here because he's appealed the ruling in an order that says that you only have to produce videos that you're going to use at trial. That's what the court ordered and that's what we produced. But he says we should be required to produce any surveillance we ever get, no matter what the category is.
Okay,
That
let
includes-
me try and ask it a different way.
Okay.
What is the entire length of the videos that you propose to offer at the trial?
At trial, all the videos we have, we intend to offer at trial. That consists of, I would say, no more than 5 minutes, and I've not timed them. But
okay,
they've been produced.
So you're saying you don't have 30 more minutes of something else over here that you don't intend to use at trial that's not been produced so far?
That's right. And the speculation that's led to this argument has been that there's non-sequential numbering of videos. There's been no discovery. No one knows how that even happens.
Wait a minute, you took video of the plaintiff, and you only took 5 minutes of video? I find that
Frankly,
incredible.
that's part of that to be asked to the private investigator. We received the videos.
Well,
We didn't
I'm
take
asking,
them ourselves.
I'm asking you, I'm really trying to figure this out.
Yeah.
If this whole appeal is over imaginary hypothetical surveillance video that might be taken in the future. Yes?
Well, yes, to some degree it is. But it's also a matter of the order that
To some
plaintiff-
degree, what does that mean?
Well, it's not only about that. It's not only about future discovery or future surveillance issue that may be issued in this case. It's also about it is in this case, but it's also about the fact that plaintiff wanted to have an order in place that said defendants always have to turn over their surveillance,
But you
regardless
can't
of the intent
assert,
to use it.
we're talking about work product.
Right.
You can't assert work product over imaginary future video. So what are we talking about here?
Could it be about the rest of the investigative file?
I'm sorry? The investigator file?
Yeah.
Yeah, we asserted the privilege over the investigator file as well, and we actually voluntarily turned that over. We've informed Mr. Zager of all of this. This has been informed to Mr. Zager. He knows this, that we've produced what we have. So I think
Well,
there's still.
what puzzles me, Mr. Dixon, why did you even file a privilege log? Why did you put items on a privilege log that you produced?
Well, we did that before we actually produced them.
Okay.
And that was helped, frankly, to avoid waiver, and we don't believe there was waiver because we were ordered to produce them from the trial court.
Okay, so what are y'all fighting about in this case?
We're fighting about the scope of an order on how much discovery is entitled to be, or how much surveillance, is entitled to be discovered by a plaintiff. And what the plaintiff has claimed is that anytime they demonstrate a substantial need for some surveillance, that opens the entire their review.
Well, so is the
We've claimed a privilege, and we're not withholding documents or videos.
Okay.
Now, again, I think this is
Why
important
did
as
I
well.
not get maybe I'm thick here, but I just didn't glean that from the brief.
That's
I just didn't
exactly
glean
what
it
I'm
from the
saying.
brief.
Looking back at it, I didn't delete it either.
Well, I think that's why I want to try and inform you on the record that they've relied on speculation and conjecture, and it's making you assume that there are some other videos, but they don't cite
But
anything.
you filed a motion to narrow the ruling to require production of only the surveillance videos defendants wish to reserve. To me, that there is something you have that you don't want to produce.
The purpose for that was for precedential value, because again, as I mentioned, we're in the largest state, or the largest county, in Tennessee. Other attorneys would use that and say that there's been a precedential value from Davidson County that says you have to produce all surveillance. And we thought that even looking at that order, it was not worded correctly. And the trial court agreed that they didn't mean to word it as broadly as they did. So that was purely to have the court order be consistent with the reasoning that it applied. And the court did that. Now, plaintiff appealed, but when they appealed, they did so without record to say there were some other videos out there.
Well, did you make this point to the Court of Appeals?
We made the point to the Court of Appeals that the trial court didn't abuse its discretion, and that they made the correct order. And that's all we had to fight about. Because the trial court did make its correct order. It just so happens that we've disclosed and provided all of the videos that we're going to be using at trial. So I think this is another key point. We've gotten off on this tangent somewhat of the applicable.
It would have been really easy to say in the briefs, we've produced all the surveillance video we have, Your Honors. We've produced all of it that we have, because that, if I understand it correctly, that's what you are telling us here and now. All the surveillance video we've taken, Your Honor, we have produced to the plaintiffs. Why are we here?
Well, I think that also goes to the fact that they've claimed a much broader application of the law, which would lead us to future surveillance, and at that point,
Then you fight over, if there's future surveillance video, then you fight over it when it comes into existence.
but they're fighting over it in a means that would implicate it now.
But
which is
that's,
why,
I'm sorry, go ahead and
Please.
finish your response.
no,
Well, it seems that the way in which this was argued below at the trial court and the Court of Appeals and now to us, it sort of was all based on this assumption or the premise that we're talking about surveillance videos that were sort of all produced within the same time frame. Right? I mean, I don't understand the plaintiff's argument at any point to have been that we're entitled to surveillance videos that may be taken, in the future. So it just seems like even if the wording of the order may have been, in your view, broader or, subject to misinterpretation or misapplication down the road, I mean, isn't the way in which, hasn't the entire argument about this issue in the proceedings thus far been based on the premise that we're talking about, a category of surveillance videos that is all occurred at about the same time? That seems to be what everyone has been, if any of my colleagues are thick, then I'm thick too, because I don't think any of us really appreciated that there may not actually be a dispute about this particular category of surveillance videos.
the only thing I can say in response is that they've been aware of the facts of this case, but then they've used this to develop this line. There's some additional withheld videos, and we're still talking about work product. And I think that we are at a point where we have to defend the trial court's order because it was correct when they're trying to expand the trial court's order when this case is still ongoing.
Well,
this
I'm sorry.
No.
Go ahead. As I understood Mr. Zager to say, the investigative report, which has been produced, seemed to indicate there were additional videos. Is that incorrect?
That's incorrect. And also, I note that the videos in the investigative report are not even a part of the record, but that's not correct. They've attempted to build this record on this appeal. Again, it's in the record. It's just speculation and innuendo. And I do want to get back to one point. Mr. Zager never requested an in-camera review. He didn't quite answer your question. They did not request an in-camera review. What they've got.
Well, why would, if they've got everything, there's nothing to review in camera, right?
Right. So leaves us with the question is, they want to get an order that allows plaintiffs to evaluate any discovery. The effect of that on a day-to-day basis in trial work, as you know, is to have a chilling effect to prevent surveillance. And surveillance is the one opportunity that defendants have to assess a plaintiff outside of what I call
We don't usually hear disputes about what might hypothetically happen in the future. I mean, is this appeal moot?